Since these matters are being presented in this fashion, the court announces that all parties are expressly prohibited from recording any portion of this proceeding by any manner whatsoever. That order applies to all except for the official court reporter, who is in fact making a record of this proceeding, just like he would do if we were all in person in this courtroom, which of course we are not. We're scattered out, frankly, around West Texas.
Yes, sir.
So for purposes of pretrial, what says the state?
State's ready, Your Honor.
And defense?
We're ready, Judge.
Do we have any pretrial matters to take up in Mr. Anderson's case at this time?
None from the state, Your Honor.
None from the defendant at this time, Your Honor. We are still waiting a plea offer in his case.
Ms. Morris, I'll send it to you again. I'm happy to. My file indicates that we sent you a discovery and an offer. January 14 is the date of my letter, but if we need to send that again, we certainly will.
Please, we got discovery, but as far as I know, no offer. So if you can just send that again.
Very well, we will.
Thank you.
Am I able to hear it right now?
You will be able to talk to your attorney. You'll want to talk to your attorney outside the presence of the district attorney and outside the presence of the court, because sometimes there are things that an attorney and client talk about that might not be best presented on the record.
Yes, sir.
Okay.
I'm just ready to get this over with, you know.
I understand.
Mr. Anderson, I'll schedule another Zoom call with you so we can discuss it, okay?
All right. Yes, ma'am.
Is there anything else then that we need to take up in Mr. Anderson's case at this time?
Nothing from the state, Your Honor.
No, Your Honor.
Then let me tell you of a plea cutoff date. But in doing so, this is probably more for Mr. Anderson's benefit than anyone else. There are other cases ahead of Mr. Anderson's case on the docket that I anticipate will actually go to trial this month, this month of February. But our plea cutoff date will be Friday, February 12. I have not spoken to the district attorney, and so I haven't even asked if the district attorney anticipates being available as late as the 12th if an agreement were to be reached.
I will be available to do a plea hearing, Judge.
Okay. If a plea agreement were to be arrived at, our schedule is full, but that does not mean we could not fit a plea in prior to that time, if that were something that all of the parties agreed to. I'm not suggesting that it should. I'm just trying to cover all of the possibilities. If the case is not disposed of by plea agreement on or before February 12, then it will be on the trial docket for Tuesday, February 23. If the case after February 12 were to reach the number one position on the trial docket, then it would be too late to enter a plea after February 12. If it is still below the first case on the trial docket for February 22nd, and a plea agreement were entered into and a desire expressed to actually engage in that plea agreement or enter a plea pursuant to that plea agreement, it could still be done even after February 12th, but only if the case is still not yet number one. Okay?
Yes, sir.
Okay. There's only one case against me, right?
Yeah, he's talking about other cases ahead of you with
All
other
right. I was just making sure I only had one case. It's like, when did I get another one?
Sorry for that confusion. No, I'm
No, that's my
talking
fault.
about other cases. There are other cases against other defendants
Okay. All right. I got you.
on our pretrial docket that are in front of yours from
Yes,
a
sir.
trial standpoint. As long as they're still going to trial, if you wanted to, I'm not trying to suggest you should,
No,
but
I
if
want
you
to get this
wanted
over
to
with.
enter a plea, you would still be allowed to do so. Once
Yeah.
your case gets to the number one position and everybody starts getting ready for trial, then it's too late to enter a plea agreement
I
plea.
really don't want to go to trial. I just want to do a plea negotiation, get this over with, so I can get back to my daughter. The
I
longer I
understand.
put it off, the more it's gonna take out of me.
I understand, but be aware that plea negotiations aren't necessarily everything you want. So
I understand
that's
that.
something you'll talk to your attorney about. And again, I advise you to talk to your attorney instead of me or Mr. Smith. Ms. Morris, is there anything else that the defense needs to present this afternoon?
No, sir.
All right, then we will be in recess in Mr. Anderson's case. Mr. Anderson, your attorney said she would set up a Zoom conference with you or another telephone or Zoom conference with you to discuss these matters. She probably, I'm not trying to put words in her mouth, she probably wants to see that plea agreement offer so she can discuss it with you
All right.
before she
Yes, sir.
calls you.
Yes,
Okay?
sir.
All right. You may be excused. Thank you, sir. You can just exit the room and they'll bring somebody else in.
Thank y'all. You have a good day.
Thank you, sir.
Thank you, Mr. Anderson.
Yes, ma'am.
He wasn't supposed to close himself off. They'll have to
no.
reestablish. That's all right.
Oh, no.
I'll take care of it, Judge.
Yes, ma'am. Thank you. After you do that, Kayla, would you bring me the current pretrial docket in?
Yes, sir.
Ms. Morris, you will be receiving an email from the coordinator in the next day or so. I would like to set up a meeting by Zoom with the attorneys who are involved in CPS cases and just those attorneys, not the CPS attorney.
Okay.
I want to get some ideas and some suggestions from those attorneys on how we can more efficiently take care of our CPS cases, whether that means all in one day or spread out or other ways. I have some ideas. I was not happy with how they went this week or how some of them have been going.
Right.
And so I want some ideas. I have some ideas of my own. I want to share them and get some feedback, but I would like for it to be with all of the attorneys who have been doing CPS cases. And so that includes, that's why I mentioned you as well.
Yes, sir.
And it will not be an edict that says the meeting will be on this date. It will be an initial opening. When can we get together by Zoom? And I know everybody's schedule is such that that may be a little bit difficult, but we will try it. All right,
Okay, yes.
let me get the jail back in. Well, we got the room back in. Good afternoon, Mr. Richardson.
Hello, how you doing, Judge?
I'm doing good, sir. We're going to take care of your pretrial hearing at this time. So let me call your cases. I call cause number 10,810 and 10,811. Each case being styled the state of Texas versus LaShondrick Delon Richardson. These cases are called for purposes of pretrial hearings. These hearings are being conducted by remote video teleconferencing technology and are being live streamed on the court's YouTube channel in order to comply with orders from the Texas Supreme Court and directives from the Office of Court Administration. As such, the court orders that no one record any portion of these proceedings by any means, electronic or otherwise, except for the official court reporter, who will in fact record these proceedings just like he would do if we were in person in the courtroom, which of course we are not because we're on this virtual hearing. Those announcements and pronouncements being made for purposes of pretrial, I recognize State's counsel to state ready to proceed.
It's ready for pretrial, Your Honor.
Next, I recognize defense. Is defense ready to proceed?
We're ready, Judge.
Do we have any pretrial matter that needs to be taken up at this time? State?
The state has no pretrial matters to be taken up at this time, Judge.
Defense?
None that I'm aware of, Judge. We filed our pretrial motions, just standard motions back in October, but I don't think there's any action necessary by the court today.
I have something to say.
What is that?
Oh, I submitted a letter to the district clerk.
I beg your pardon?
So I submitted a letter to the district clerk that's for in regards to my case. That's due to a conflict of interest between me and my attorney, due to an open bar complaint that's going on.
And
Judge, I'm sorry.
no, go ahead.
If the defendant is intending that to be a motion for me to withdraw as his counsel, I would gladly file that motion, Judge. He has filed a grievance against me with the state bar. I haven't filed the motion simply because he hasn't re-requested that I file a motion to withdraw. But if that's his motion to today, then I would concur.
Yes, I considered in there to release you as my attorney.
I'm sorry, sir. I can't understand.
Can you hear me?
I can hear you,
Okay.
but I couldn't understand what you said. Say it again.
Oh, I filed a informal letter with the district clerk pertaining to my case. It's about a conflict of interest between me and Leanne Morris due to an open bar complaint that's going on. And I requested to release her as my attorney if possible.
And what was the nature of your complaint?
I filed a grievance against Leanne Morris, and there's an open investigation within the bar, state bar, chief disciplinary counsel.
You cannot create a conflict by filing a complaint and then saying there's a conflict.
No, she's already received it. She's aware of it as well.
That's not what I said. You can't artificially create a conflict by saying, I filed a complaint against my attorney, therefore there is a conflict. You haven't told me the nature of that complaint. Sir?
Well, the nature of the complaint is she knows about it and I know about it, so I don't want to be a victim of biased treatment or unjust, anything like that. Because she knows our response, and she was very unprofessional in her response to the grievance. Therefore, there's reason to believe that my best interest is not in it.
Well, I don't have that. I don't know that. And you've not provided me with any basis for knowing that. Just saying that you have filed a complaint.
I have the proof right here. I mean, I got the state board paper right here. I have the evidence from the state board. I have my letter, which I submitted to you on February the 1st to the district clerk due to the fact that you don't read the direct mail.
I'm not sure what you mean by the comment that I don't read the direct mail. What I do not do is take ex parte communications. And if that means I don't read direct mail, that's because I don't read ex parte communications. Ex parte communications, you understand what that is?
Yes, sir. That's what I'm referring to.
Okay. Well, as I say, without any information whatsoever, there's no basis for me to believe there is a conflict just because you filed a complaint against your attorney. If that were the case, every defendant could say, I'll get a postponement in this case by filing a complaint against my attorney. Therefore, I can then say we have a conflict and I get somebody else. That's not.
It's the fact that there's an investigation going on, so there hasn't been any resolvement within the chief disciplinary counsel. So, I mean, if there's an investigation for professional misconduct going on and she's been accused of professional misconduct, I mean, I see no reason for her to continue to stand in without getting a result from the chief disciplinary.
I don't know that there is an investigation going on. And besides, if there was an investigation, you haven't made this court aware of it, other than saying globally there is an investigation.
You didn't receive my letter then.
I beg your pardon?
I said you didn't receive the correspondence.
Which correspondence?
The one I'm telling you that I submitted.
The one you
Before
said
the
you sent
pretrial.
to that you sent to the district clerk?
Of the courts, of your courts, yes, sir.
Well, if it's a letter to the district clerk, then of course I haven't seen it. It's to the district clerk. But since you have not presented, you have not filed a pleading, you have not presented any suggestion other than you filed a complaint. You haven't even said what the complaint was about or why it's being investigated, or you said it is being investigated. I don't know what you mean by that. And I have not seen anything that would suggest that there is a basis for a complaint, but that again is because you haven't presented same to me. At this point in time, there is nothing for me to consider.
That's fine. I mean, the essence of the complaint is considered confidential through the state bar, so I can't go into detail as far as what's going on.
That's fine. If it's confidential between you and the state bar, then it's confidential between you and the state bar. And it's not in front of me. And if it's not in front of me, there's nothing that I can do to act on it. There's
Okay.
no complaint in front of me.
Well, I'll submit the paperwork to you.
Anything that you present to me must be presented to all other parties. Otherwise, it's ex parte.
Okay.
All right. Is there anything else that we need to take up in Mr. Richardson's case at this time?
I have nothing else, Your Honor. One other thing, Judge, and I may have said this in some of our previous pretrials. If these cases require a trial, trials, I intend to try them separately. And the first case the state would elect to go to trial on would be cause number 10,811. That's the unlawful possession of a firearm by a felon case.
All right. The plea cutoff for this case is February 12, 2021 by end of day. That is not a requirement at all. That is merely the time by which a case on this docket, if it desires to be disposed of by a plea agreement, a guilty plea pursuant to a plea agreement, that must be conducted by the end of day, February 12, unless the case is still not scheduled number one for trial on February 22nd. Which is Monday, February 22nd is Monday, Tuesday, February 23rd. One of those days would be our trial date. At the moment, Mr. Richardson, there are other cases in front of your case, other defendants' cases in front of your case on the trial docket. And so if those cases still remain and one of them is to go to trial, the plea cutoff date of February 12 doesn't become effective until such time as your case becomes the first case on the docket.
Yes, sir.
All right, sir.
And do you know what number he is, Judge, as of right now?
Yes, ma'am. Well, I say I do. He possibly is number 2. He is possibly number 3.
There's really there's really just 2 defendants ahead of Mr. Richardson.
Okay,
And I have an early indication that at least one of those is going to plea.
okay. Do you know which 2 attorneys those are?
The 2 attorneys are Trey Keith and Trey Keith.
Okay, just like last time. Okay.
All right. Then we will be in recess in our pretrial hearings. Thank you. You may be excused, Mr. Richardson.
Thank you. I'm done.
I removed the laptop this time.
And
I'm sorry about that. If you're going to practice criminal law, you're going to meet those type of people.
Thank you, Judge.